Welcome to the Startup Leaders Show, where we learn lessons from startup founders and executives. I am your host, Lisa Dreher, and I am really excited to introduce our guest for today, Numa Isnard. He is the founding partner of SpaceAvocat. Welcome to the show, Numa.
Thank you so much, Lisa. Thank you so much for having me tonight.
Thank you for making time for this. Maybe you can start by giving us a little bit of background on yourself and SpaceAvocat.
Sure. Well, SpaceAvocat is a law firm based in Paris, but acting worldwide. And so I created the firm in 2021. I myself, I'm an attorney based in Paris also, and educated in La Sorbonne University and then Berkeley Law. And my specialty is space. So I basically provide legal services, legal and regulatory services to a space company. Wherever they are, they can be new space startups, they can be SMEs, they can be international groups, or even foreign governments. The idea is really to provide sector-specific advice. So I know the sector, so I can speak the same language as a client. That's the value added of the service that we provide at SpaceAvocat.
Excellent. Well, I'm really excited to have you here today because this is a really interesting topic for us. We focus a lot on technology and space industry topics and speak with a lot of leaders from companies like this, but we haven't spoken with anyone in the past about specifics related to the law and the space industry. So I'm really excited to speak with you today.
Well, it's always good to talk about the law. And the good thing is that it's early morning in the US, so people can still recover after the legalese and the weight of the discussion.
Exactly. Can you talk a little bit about, I guess, a little bit more about the services that you are offering and some of the things that you focus on within your business?
Of course. The idea, as I was mentioning, is that the firm is very niche, but the scope of service we are providing to the clients is really broad within this niche, because the space sector per se, and that's really the original competence of the firm, is regulatory, because it's super regulated. It's launching a satellite involves a rocket, which is a very dangerous object. It's a very dangerous and risky activity, so you have a lot of authorization, licensing. Wherever you are, can be US, France, wherever country, India, you need to have all this regulatory part. But since a lot of space actors are companies, they have other needs, such as corporates. They want to raise money. They have corporate issues like any other type of company. So we are also here to assist them, and with the the specificity of attorneys, that we are independent per se. So we are able to collaborate and create teams very tailored regarding the needs of the clients. For instance, I have some clients, they're willing to let's say incorporate another company in the United States. So they call me, and I've got my network there, and I don't under the same brand as SpaceAvocat, they have the full service. So they have the advantage of the full service without the remaining cost of big structures.
Got it. So, as you're working with these new space companies, what are you coming across as some of the most common legal mistakes that these companies are making or are liable to make?
Well, that's it's too often people see lawyers and attorney as they are here to point out the mistakes, how they did something bad, and it's complicated to be an entrepreneur. That looks really obvious to say that, but there is so many parameters to think about it, and especially when you are venturing in space, which is super risky, super capital intensive. So you burn a lot of cash, and so you have a lot of things to think, and then you have all this contractual aspect, you have all the IP aspect, all the regulatory aspect. So a lot of things to do. And then you are mentioning mistake. I think one of the mistake is not seeking for help when it starts to get serious, because generally, especially in the new space, you have people with technical background and or business, and they come together with an idea because they think there is a market or potential service for clients. So they focus really hard on the technology and on the services, which is good. But when they start to incorporate the company, sometimes they are like, we don't want to spend too much money in there. We prefer to keep the capital for all the super interesting technology we are developing, which is the right thing to do. The problem is, don't forget that the corporate shell that you are building is going to last. So if you start with shareholder agreement, which is a little bit not really stable, not unsure, don't forget that you're going to have to raise capital. So it's the first piece of advice would really be to even if it's heavy, if it's a burden, invest in the legal structure of your company. Make something clear with reputable attorneys so you can have something that is reliable, that's going to last for a while. So when you're going to have investor coming up, they will not be afraid by the fact that the company is a little bit squeaky. You want really to have something that is stable and that is professional. So also that can attract investors. They're going to be like, okay, there's no red flag for this. The other problem is really IP. Because talking about innovation, intellectual property is the cornerstone of innovation. If you want your company to have a value, you need to have assets, and IP is clearly an asset. The problem is too often people are like, either they are perfectionists, in space, they want everything to be perfect. So like, that's nothing. We just created, that's just coded these things in a few hours. That's worth nothing. You don't know. You never know how much it is. So it's better to really have a safe approach. The idea is not really to fortress the company, but just to control. So for instance, when you are signing NDA, take a look at it. Don't think, that's just a piece of paper. In any case, we're going to be screwed. It's a huge company, so we just signed the deal and we don't read it. So that would be the two pieces of advice.
Great.
Really invest and read the document to avoid a mistake.
Read that fine print, right? All those
Pay
legal
attention to fine print. Yeah, that looks really obvious to say that, but even the most basic like NDAs, because we sign NDA in the legal industry every day, they are important because they are foundational. And if I have just a couple extra seconds, I can just explain a very simple case. It's like when you sign an NDA, the big parameters of the potential big contracts coming after that will be laid off. Like for instance, the jurisdiction. If you want to have an American contract, if you want to have a French contract, you have to start thinking about it in the NDA. Because when you're gonna, if you go further in the business relation, your counterpart will say, "Oh, it was a Swiss, it was a Indian contract. So why do you want to change the jurisdiction now?" And that's something that can impact your company because you don't want to go to court in a country that you don't know or you don't have any attached to. So that's why it's important to think forward in this.
Yes, absolutely. What are some of the considerations related to regulatory, spectrum? I think in this industry, it gets a lot of attention, and obviously there's a lot of competition for the spectrum and things like that. And then, like you're saying, there's a lot of regulatory considerations. What are some of the things that we need to look at from a legal perspective when it comes to regulatory and spectrum?
Yeah, that's a great question because it's foundational. We were talking about more business part of the legal aspect. This is like yes or no. If you don't comply with it, the government gonna shut you down. So that's something you really need to pay attention like every day. The first regulatory parameter is authorization. If you are launching something, you need to be authorized because, long story short, you have international treaties regulating outer space. And the states are the parties to these treaties. I mean that they are the subject to the regulation. But as a consequences, as you are a member of the state, as a citizen or as a company, you have to comply with the regulation that are themselves complying with international regulation. So that's why you have this regulatory part, which is so important in the space sector. So authorizations first, especially if you want to launch. Like big company like Ariane or SpaceX, they're gonna ask you the papers. Did you file the authorization? Do you have the authorization to fly with us? Otherwise, you're out. And it can be on the contract very harsh. So you have to be really on time to deliver this authorization. Other authorization you may have is especially if you are doing Earth observation or remote sensing. Some jurisdiction, most of the jurisdiction right now, they are regulating it, meaning that if you have satellites, okay, you got your authorization to launch the satellites. You can launch it. You have it online. It works. Great. You have the authorization to use the image. If you don't have it, you can't sell them. You can't even use them. So you need to really be careful to that. So that would be licensing to launch, permit to exploit, to be an operator. And then you were mentioning this very, very tricky part, which is licensing and for the spectrum. Of course, you don't want to send a rock. You want to send something that is able to communicate with you. Because if the satellite doesn't have any spectrum authorization, it cannot talk, it cannot listen to you. There is no relation. So that's also something the launch company will ask you to show. Did you file all the authorization with the International Telecommunication Union? That's something super critical, scares a lot of companies, but that's not so big. The two big advice are: first, establish a relationship via your attorney or any consultant you may work with. Establish a relationship with the administration in charge of the spectrum in your country. Like, for instance, if you're in France or United States, go to see the administration in charge, explain the project and what do you need to actually make it work. So every project is unique, and you may need very specific spectrum resources. So you better, at the earliest time you can, talk with your government. Okay, well, this is what I need, and how can you help me? How can I help you? Also, give me the authorization. And then you have all this regulatory process that can last months, when your government is basically proxy you in the international level and sending you, okay, this company wants to have this type of spectrum resources. It's basically what you guys think. So all the government will reply to you and say, okay, I'm the Republic of France, I am in England, I am Italy. So okay, this is okay for me, this is not okay for me. And then you coordinate. So you try to find a solution. Okay, you are using this, but you just need that. Is it okay for you? Okay, let's sign an agreement. And then next. So that's a very, very lengthy and it can ask a lot of work, especially if you are an early stage startup. So that's why it's something you need to budgetize, and you need to think very, very, very early stage on your project.
Right. Okay. So are there legal implications as space becomes more and more commercialized that we need to think about, or that are just influencing how the industry continues to progress forward?
Well, the question goes a little bit beyond the law, but regarding the legal part of the operation, the fact that you have a lot more new actors coming up, and you have like non-space specific companies venturing in outer space, from a regulatory standpoint, especially, that changed a little bit the game, because government and administration were used to have, the usual suspects, the old legacy player that they know. Some of them are even, privatized, formerly state-owned companies. So team were used to work together, and then pick up the phone, ask for authorization. Okay, let's file a paper. We know it's going to work. Now it's completely different. So it's more like, we started from a very state-owned, or at least very controlled sector, to a more like regulated one, like the telecommunication market. It's private company, and they most of them are 100% private capital. So the government has to adapt the authorization regime to have something very transparent, very clear, and so that needs some time. Especially, I was mentioning, for instance, Earth observation permit. Same. Government were used to have like national or international constellation. Now you have private company trying to venture in outer space with Earth observation. That's an adaptation of the regulation. So that's, from a legal standpoint, the interesting thing is that new space, and now people are talking about next space, is changing a little bit the way the government are interacting with company. Government and companies are both trying to learn how to work together. Startups they just start, so they try to understand how they can implement early stage a regulatory process, which is unusual when you are doing startup. Generally, you are focusing on the market and the client, but okay, you have also to think about how our relation with the government, and then the government also has to think, okay, I'm used to work with big semi-defense company, and I have startup funded by engineering students, but I need to talk to them seriously, because they can be the next Elon Musk. So I need to be also careful on this, because something that we didn't mention is that space is very connected to national pride, national industry. So that's something that's also why the government are really, really keen to analyze and understand what you want to do. So yeah, the new space really impacted the legal part on vis-a-vis the relationship with the government and the new space. The rest is more like a new company trying to emerge on the market, trying to make its room in this market.
Right. One of the things that I think we're seeing a lot in the space industry recently, and well, I guess over the last several years, are a lot of mergers and acquisitions and things like that. And obviously, one of the exit strategies for a new space company may be to sell that company to a larger company. What are some of the legal things that we need to think about as our companies grow and potentially get wrapped into other organizations?
That's a great question because the internationally now the scene is more growing. Like you have a lot of initiative, a lot of ventures, but as you clearly mentioned, as any economical cycle, there is a time to consolidate, and maybe then we're gonna have another revolution in the same sector. But yeah, right now it's exploding everywhere. But we may have some M&A operations. The important thing to think about when you are a startup or venturer is that the company that's going to purchase your business uh, will do a background check, and that's what we call in the legalese due diligence. And
Mhm.
basically, their objective is to remove any red flag that could put some risks. They want to mitigate the risk. And don't forget that space is already a super risky business. First, technology is very, very elaborated, so it needs to work. Second, it's highly regulated with the government, so you need to have the right authorization. Third, the geopolitical play is also an impacting parameter. So you have all this in your company. So if you have any red flag, legal red flag, even like an IP that you don't really know if you own the patent, the potential purchaser will say, okay, that may lower the value of the company if I'm not really sure of this. So you have to, as a space entrepreneur, when you are doing M&A operation, you have to be careful about the usual operation of your new space company, like any other like any other normal company, plus all the specific parameter of space. Do you have the correct authorization? Are your satellites compliant with all the authorization regarding the exploitation, like for instance Earth observation? Are your licenses up to date? Do you have all the patents clear? So that's something that you need to pay attention when you are engaging this. Also, something very interesting, very important, relating to what we were discussing earlier. When I was mentioning, invest a little bit in the legal, even if it's early stage and that's painful for the money. That when you have the shareholders, put some ground rules at the beginning, because
Mhm.
when you want to get out, if it's a mess, if there is no clear rules, you always have a potential shareholder saying, I think this offer is not good, I don't want to do that. And everything is blocked because you didn't really prepare the ground rules between the shareholders. So pay attention to this. That's a really early stage stuff, but that may account on the exit.
Indeed. Okay. So if somebody wanted to learn more about Space Advocate, what should they do?
Well, they can email me anytime. I'm sure you have all the contact, and also the firm as a podcast. So if they want to learn more, they can hear the podcast on any platform and YouTube.
Great. And I think they can find you on LinkedIn too. So that's always
Yes,
a
yes, pretty
good
active
place
there.
to go. Well, Numa, I want to thank you so much for being here today. This has been incredibly informative and
Thank you
we
so
really
much.
appreciate your time.
Of course, anytime. Thank you again, Lisa.
Absolutely. Hopefully we can have you back again soon.
Of course, my pleasure.